A better approach to Utah divorce and child custody litigation. Utah's family law system has some serious flaws, most of them rooted in inefficiency, guesswork, reliance on adult-filtered narratives, and just general mediocrity. But we could fix a lot of this with a few simple reforms. First, every case should begin with a master trial issues list. Instead of guessing what the other side wants or chasing phantom issues, both parties file a list of their disputed matters and the court consolidates them into one master list. Now everyone knows exactly what's at stake and what those exact issues are. It cuts out posturing and eliminates unnecessary discovery. Well, at least it should. Speaking of discovery, an issues list makes it disciplined and proportional. If a request doesn't relate to an actual disputed issue, the receiving party can shut it down more easily by pointing to the issues list. This stops the fishing expeditions, the harassment in discovery, and the gamesmanship that drive people into financial exhaustion. Second, Utah needs early on-the-record judicial interviews of children whenever child custody is disputed. Not months into the case, not after narratives harden and coaching creeps in. Children should be interviewed within weeks of the petition being filed, in camera, recorded, with both sides able to observe. That single change would dramatically reduce manipulation and hearsay contamination. Not eliminate it, but reduce it. Third, the objections to judicial interviews of kids will be traumatized, judges aren't trained, and it puts the child in the middle are exaggerated or flat out incorrect or misleading. Children testify safely in juvenile and criminal cases and other civil cases all the time. Judges are perfectly capable of conducting respectful and competent interviews. Nothing puts a child more in the middle than adults fighting over them without ever hearing from the children themselves. When courts rely on a PGAL interpretation or evaluator summaries or therapist impressions instead of a child's actual voice, unredacted, the process becomes less accurate and more vulnerable to distortion. Direct early interviews fix that. Utah doesn't need radical reform. It needs transparency, discipline, and evidence, not avoidance. A few practical changes would dramatically improve how custody and divorce cases are litigated, and more importantly, how decisions that concern minor children are actually made.